120 WPM English shorthand dictation. Be ready for it. Start. Para. Debates leave no room for doubt that the 2012 Amending Act clearly intends to preserve the status of the university and also the extent of reservation in favor of scheduled castes, scheduled tribes as was existing prior to the 2006 Act. Para. Having noticed the factual basis for the preferment of the petition and the disclosures made by the respondents, we now proceed to note the primary legal submissions which have been advanced in these proceedings. Learned counsel for the petitioner, while reiterating the averments made in the writ petition, has contended that large-scale scams occurred in the authorities and more particularly Noida, clearly being indicative of the fact that all was not well. Full stop. He asserted that the state government, even in the matter of posting of officers, must act in a manner which inspires confidence in the public at large, and that its action must not reflect of favoritism in favor of a select few. Full stop. It was contended that the continuance of the 12th respondent was clearly detrimental to the public interest without justification in law, and that the state government was continuing to accord him protection despite various scams and allegations having been leveled against the 12th respondent and Noida. Full stop. It was therefore submitted that larger public interest clearly warranted removal of the 12th respondent from the post of CEO Noida. Full stop. Para. The learned counsels for the respondents have, apart from addressing submissions on the merits of the allegations labeled in the petition, in unison taken serious objection to the entertainment of the PIL itself, and have submitted that the instant petition was neither bona fide or did it espouse any issue of public interest. Full stop. In this respect, we note that not only the learned advocate general but also Shri Ravi Kant, learned senior counsel, and Shri Ravindra Singh, learned counsel, who appeared for the 12th respondent, have taken serious objection to this court having entertained the instant PIL itself. Full stop. It was submitted that the instant proceedings are a clear abuse of the process of court, and it is apparent that quite far from espousing any issue of public interest, the same has come to be instituted at the behest and instance of unknown and interested quarters. Learned counsel drew the attention of the court to the fact that the petitioner was stated to be a society registered and resident at Allahabad, and that in the entire petition there was no material which may have even remotely indicated its activities or area of operations. Full stop. It was alleged that there was a complete non-disclosure in the writ petition of particulars required under Chapter 12, Rule 3A of the Allahabad High Court Rules 1925. Learned counsel submitted that the writ petition carried not one averment of any public or social service which the petitioner society may be stated to have performed. Full stop. Additionally, it was contended that the writ petition itself did not bring on record either the memorandum or articles of the society so as to indicate its aims and objectives in full stop. In fact, learned counsel submitted that the petition had been instituted and entertained even in the absence of a resolution of the society deciding to institute the present proceedings and authorizing the petitioner in that regard. Para. Under an obligation to have decided the issue of membership, it is apparent from the objections raised by the respondent number 2 at every stage that he had been contesting the very electoral college of 24 members of the deputy registrar, indicating it to be the fake list, which was not adjudicated upon considering the objections of the respondent number 2 in the order dated 6/8 2013. In our opinion, this was a blatant flaw in the order of the deputy registrar. Full stop.